So I'm going to briefly hit a few of the points that I think create a context, historically and otherwise, for this discussion. Then I'll give way to Terry to talk about some of the flashpoint issues that we now deal with the state and its local governments need to deal with going forward, having passed the 50-year mark. Now, in case you were not aware of this, although you may be, New York is by far the nation's most heavily unionized state. A total of 25% of all the private and public positions in our economy are covered by union contracts. Roughly half of the unionized positions are in state and local government. In fact, 3/4 of the state and local government jobs are covered by union contracts in New York State, which is almost double the national average. We are much greater than the national average in public sector unionization than in private sector unionization, where we're perhaps 50% above average. With 60 full-time equivalent employees per 1,000 residents, our state and local workforce is 18% larger than the national average and the largest of any of the most populous states. In 8 of New York's 10 labor regions, the average state and local government salary is higher than the average private sector salary, and which might surprise you to hear that aside from the North Country, which is very thinly populated and underdeveloped, the highest ratio of state and local government salaries to private salaries is actually in the state's expensive suburbs, in Long Island and the lower Hudson Valley. That is where government salaries are highest relative to private salaries. The members of the police and fire retirement system are the highest paid employees in New York's public sector, with average salaries reaching $157,000 a year for county police, mainly in Long Island, and $111,000 for the thousand for state police, and $102,000 for county police, town police. And over the past 20 years, as shown in our report, the average pay of police and fire system members has risen considerably faster than the average for all members of the employee retirement system. Now, underlying all this is that certainly the passage of the Taylor Law marked an important turning point for the state that has been affecting the state ever since in different ways. In the early 60s, as recently as the early 60s, and this may be a surprise to hear, New York was not a high-tax state. This has not been a permanent condition in New York. In the early 60s, we were only 9% above the U.S. average for local and state taxes relative to income. It was in the mid-60s that we began to take off to the level we're at today, which is number 1. And basically it coincided with 2 events. It coincided with the invention of our Medicaid program and with the passage of the Taylor Law. Now, a little bit more historical background I think that is important to keep in mind when it comes to the background of the Taylor Law. The 1938 state constitution gave employees the right to organize and seek collective bargain, all employees, without regard to sector, but did not obligate government employers to bargain with their employees. In fact, prior to the 1950s, there was a very broad legal and political consensus here in New York and across the country that collective bargaining in the public sector was inappropriate and shouldn't be allowed, and that was an opinion shared and articulated by no less than Franklin Roosevelt, among others. This did not mean that public sector employees were being left behind, however. The civil service salary grading system, including annual pay increments, was introduced in New York in 1937. By 1941, civil service employees had the right to a hearing if faced with disciplinary charges. In 1955, all competitive class employees were granted tenure. The first state government employee retirement system was created in 1920. Public pensions were guaranteed by the Constitution in 1938, and pensions were available to virtually all full-time public employees by the 1950s. So, in other words, before collective bargaining commenced anywhere in New York's public sector, public employees were already entitled by law to benefits and privileges that private sector unions had to organize to fight for. Another key development that actually brought about then the transition to the Taylor Law was the labor unrest in New York City in the early 60s, which actually, ironically enough, followed the authorization of public sector unions and bargaining under Mayor Wagner in the late 50s. So, having reviewed all of this history up until then, what happened was after the 1966 transit strike, Governor Rockefeller formed a committee headed by a noted labor law expert at University of Pennsylvania named Taylor to study the situation and recommend changes. And the name of that committee and the author of that report gave his name to the law. There were the key aspects of the Taylor law to start with were it created the right to organize. It empowered local governments to negotiate with employees who had organized in unions. It created the Public Employment Relations Board to regulate the system and to be the administrative body in determining disputes over interpretation of the law. Last but not least, it outlawed strikes by public employee unions. Now, one thing that also needs to be clarified is there's never been a right to strike for public employee unions in New York State at any time in history. In fact, prior to the enactment of the Taylor Law, there was a law known as the Condon-Wadlin Act, in effect for decades, whose penalties were seen as so draconian that they actually were among the reasons why the Taylor Law was enacted, because the Taylor Law was enacted to create what were in effect, to begin with, some more moderate and regularized penalties that existed under the Condon-Wadlin Act, because the previous law was so severe it was never even enforced, or rarely enforced. Some key changes that have affected disputes in the public sector to this day, to the Taylor Law, were not enacted were enacted only after the Taylor Law was first enacted in subsequent years. For instance, the original Taylor Committee had recommended, as Terry pointed out in his research for this, that the Taylor Committee recommended against the use of compulsory binding interest arbitration for any sort of dispute. Specifically recommended against it. In 1974, however, it was authorized for impasses in fire and police union disputes. Other important trends in the evolution of the Taylor Law included the administrative rulings that created what was known as the Triborough Doctrine, and ultimately which led almost a decade later to the enactment of the Triborough Amendment, the authorization of the collection of agency fees in 1977, and a few years earlier, the prohibition of any bargaining on public pension issues. These are all things that happened after the Taylor Law was enacted and were important mileposts in its development. So we've described how these trends played out in the courts and in the administrative decisions of PERB. We close with several recommendations in general, which have been revised only slightly based on what we recommended 10 years ago. Those recommendations are that in arbitration, when it comes to interest arbitration, that affordability should be the most heavily weighted factor without exception in determining the size of the settlement. In fact, under the law as amended in 2013, for distressed municipalities only, it can or should be weighted up to 70%. The argument might be that basically that requires that you weight ability to pay most heavily only after a contract is proven to be unaffordable. Second, settlements under arbitration settlements should be linked to the property tax cap and its limitation on property tax levies. Another point which we've made in the past is that the Triborough Amendment should be repealed insofar specifically as it affects incremental pay increases after the expiration of a contract. That PERB rulings on so-called mandatory items of negotiation also need to be reformed and clarified. Among other things, at present, these can restrict the ability of government employers to pursue subcontracting and cost savings and more flexible arrangements for sharing services or providing services. We also suggest that retiree health benefits like pensions be removed from the scope of negotiations due to the impact, real and potential, on the long-term finances of government employers. And we think that past practices should be considered binding on employers only if they were explicitly authorized in the same way as, with the same authority as other contract provisions. And last but not least, we think that employers also need more discretion in determining the fitness of employees to return to full and light duty under municipal law provisions. These were some of the issues identified mostly in the original report, teased out a little bit more in the subsequent report. And I will now turn it over to Terry to talk about some of the flashpoint issues that he thinks are important today. So So thank you very much, and here is Terry O'Neill.
For those of you who don't know, this lawyer's talk too much, so I have a timer I'm putting on myself here, so I don't go over. I'm from Long Beach, New York, Long Island. It's a blue-collar community that probably most famous for having the highest surge during Sandy, 17 feet, and also famous for our last police officer who retired had a payout of $700,000. So that's made us a bit infamous. I didn't represent them before that. I do. I'm sorry? Ah, congratulations. If I get that new mansion you moved into, right? It's a very interesting place. We are now also a fiscally distressed city. I only recently was retained to do the labor work, and we're now involved in police interest arbitration. And very quickly, there was supposed to be a session today that the union canceled because of the city's financial condition. What? That's why we're here. And also because they were not prepared. So they granted the adjournment, and I was able to make it today. I only found out Thursday. So I was also a history major in college, and I believe history is very important. And the older you get, the more valuable it is to you. For those of you who don't have the history that I have, I've been doing this for a long time. And the one thing, if you haven't read any part of the report, the historical background is terrific. It really tells you a lot about the town wall, why it's here, and how it came about. And I think that it helps people. So EJ said to me, okay, you're going to have about 15 minutes. Try to pick out one or two topics. So, of course, I didn't know I was coming here until Thursday. So last night in the hotel, I go through the report, and I start listing topics. So I'm up to, at one point last night, the following. For police and fire, interest arbitration. For police and fire, 207, whether it's A for firefighters or C for police. Manning, both police and fire. The payouts I just talked about, if you're from Long Island or Rockland County. Rockland County somehow jumped over Westchester, but Rockland County has the same kind of payouts that we have, which are not sustainable. We have a police officer who retires in Long Beach, and we have to take out a bond. We can't pay for it with normal money. So the other issues were sort of that were peculiar to the police. You have body cams, GPS issues, and then the issue about the manning goes to both police and fire. I guess my favorite manning story is in the early 70s. I worked with a guy named Bert Pogerman, who's still working. He's 86 years old. He's a partner in a different firm. Tried a jury trial about 2 years ago, which shocked me. And so I have a lot of years to go before I catch up with him. But he tried a case at PERB over minimum manning. It's about firefighters, how many firefighters could be in a rig, whether you had to negotiate that. It's in the beginning of the tail law, don't forget, the tail law was about 5 years old then. So he lost the case. So we argued in that case. Of course, when you're young, you write the papers, and the older guy does the presentation. So what I do now, I do the presentation, the younger people write most of the stuff for me. I still read it and play around with it, but they get a lot of the heavy lifting. So he lost that case, and we had argued, the next thing they'll be asking is how many cops are going to be in a car. Now, obviously, if you have to negotiate that, and you negotiate 2-man patrol cars, you can put out half the amount of cars as you can if you have one person in a car. Not decisions for me to make, but decisions for the elected, in my opinion, decisions for the elected officials to make. So in that case, I did the police case, which is referred to in anything you read about the tail law, White Plains 2. The first one was the city White Plains firefighter, the second was White Plains PBA. And PERB reversed itself, so I never let him hear the end of it. To this day, when I see him, I remind him of it. But in any event, minimum manning per piece of apparatus is not a mandatory subject to bargaining. That doesn't mean it's not in a lot of contracts. Presently, I'm involved in the city of Watertown. If you follow firefighter negotiations, it's on the newspapers a lot. I was hired there to basically have their minimum manning clause declared unenforceable. And the irony of that is the basis for that was a 1976 case in the city of Long Beach. So there's a connection there also. And we won in the Supreme Court so far, and the judge declared the provision that provided for 15 people on the tour to be unenforceable, for it didn't meet the criteria of a Court of Appeals case. So the manning issue applies to both. The 207 stuff, there's, for those of you who lived through what they call the heightened risk standard for those statutes, So if you were in your desk and a TV fell off the stand and hit you, that wasn't a police duty that you were injured by. It was something that could happen to a secretary or anybody else. But if you were out doing police work, shot, beat up, hurt in what we would call, what the judge actually called the heightened risk of police duty, you should get 207. And I only thought that was a good standard. I was an adjunct for many years at St. John's Law School. I taught public sector labor law, and I got on the elevator one day going to my class with the author of that decision, Justice Barracosa, who was, and I actually thanked him. He said, why? And I explained it to him. That was subsequently reversed. And now the guy who's there in the television falls, he gets 207. And if it happens to be a firefighter, he doesn't just get 207 while he's working. If he's fortunate enough to get a disability retirement, he then gets his money tax-free, not just the disability retirement tax-free at 50 or 75%, but then the community has to make up the difference between that and 100% of his salary until he reaches mandatory retirement age. I had a guy who just got it at 42 years age, so that means at least for 20 more years. So I'm looking at those issues, and then I said, well, there are teacher issues here, and I had the pleasure of representing the city of Buffalo. For those of you who might have been at the 50th anniversary, I was referred to as the outside negotiator, and I did the negotiations there with the teachers who hadn't had a contract in 14 years, and then there was a change in the board, and the day after the election, I was let go, which made sense. I believe you're supposed to reflect the people who are elected, and they put those people in. They all happen to be supported by the teachers union. The 4 people who voted onto the Board of Education in Buffalo turned the majority around, and they were all supported by Phil Roemer, who's been there for, he's 86, he's still the president, I think. He hasn't taught since the mid-80s, but very effective guy. I happen to get along with him pretty well, but it's a contract that not only strangles you. When I was negotiating there, I tried to impress upon them, we have the lowest performing students in the state. We have 34 schools that are under watch by, that's maybe an exaggeration, but not by much. 34 of our schools were under watch by the commissioner, and we had the shortest school day, the shortest school year, and they will tell you that the reason, that's why they pay $20,000 less, and if you actually dig into the economics, they're probably the second or third most highly compensated teacher group in Erie County, comparing a city urban school district with suburban wealthier communities. So they weren't doing badly. So there are issues there that are very important. The Triborough Amendment, which went through a Triborough doctrine that happened in '72. Then there was a case that said, okay, teachers can't get increments under the Triborough doctrine, Court of Appeals case. And then the legislature said, well, we can't allow that to happen, so they passed the Triborough Amendment, which said all the provisions of the contract continue after and construed to mean increments. So teachers still get increments, which is usually, you can plus or minus 2%. That's built in every time you negotiate. And then the 4th category I looked at was PERB. Having lived through many chair people at PERB and many boards that were pro-union, never many I thought were pro-employer, but they now have issues that they've dealt with, like retiree health insurance. They made it mandatorily negotiable, but once you negotiate and you put it in a contract and people are retired, you have no one to negotiate with to change it. Not a bad thing, frankly. Even when I was young, I thought, don't go after the retirees, go after the actives, you know. You get it from the people who are making the most amount of money, but it's a huge, huge unfunded liability that when you look at budgets, it just keeps going up and up. People live longer, it keeps up and up, and it's strangling almost every school district I've ever been associated with. Subcontracting, an issue that, you know, you would think in the private sector understand why you have to negotiate that with a union. It's a profit motive there. So people are going to move things to, you know, the south. Well, you can't move your school district to the south. You can't move your city or village to the south. So why we have to negotiate that with the union, to impasse and have a third party decide whether you can do it, is something that I thought needs some looking at. And then there's this whole concept about what unions own. They call it unit work. And I'm involved in a case now with the fire department where you can't find unit work anywhere in the contract. You can't find anything that says they get work preservation. But some arbitrator, before my time, I'm happy to say I've come in after that, decided that the paid firefighters, the combination fire department, are responsible for all the first line apparatus, and they have to go out first before the volunteers can go out. And it literally led to a situation where the volunteers were standing down, sitting in the firehouse on their apparatus, waiting for the paid guys to come for another firehouse to get the ladder to go out. We tried to get that case to the Court of Appeals, a subsequent one. We couldn't get it to the Court of Appeals, and now there's 3 other cases based on that. And then the thing that was already mentioned about the past practices. And the law used to be, for a past practice to be binding, it had to have the approval of the chief executive officer and or the legislative body. If you ever read the tail law, which I used to do every year, I read it over again before I taught, and there's a definition section. It talks about agreement, defines an agreement. And it says an agreement is an exchange of promises between the chief executive officer and the union. That's it. Chief executive officers have tremendous powers. There's a little balancing of power there by saying if it involves the appropriation of funds, well then the legislative body has to approve it. If you ever look at that funny clause that's in all your contracts, it's called the 204A notice. So if you have to do those two things, if you have to get the approval of the chief executive officer and the legislative body, why can someone who's running a garage bind you to give people the use of the garage to work on their cars on weekends, take home cars? That makes no sense to me. And the definition that they use now is the practice has to be in existence for a reasonable time for the employees to expect that it's going to continue. I really don't get that PERB concept. It makes absolutely no sense to me. How you can bind an employer without having any of the elected officials or the chief executive officer even aware of something. And I had a lot of cases before where we got best practice cases knocked out when that was the law. Well, it's not the law anymore. And then the last one I had on my little list was, well, the retiree health insurance. So, no, I'm sorry, the stays of arbitration. Now, people used to talk to me who do this for a living, you know, we talk to each other, and they say, we can never get a stay of arbitration. Well, years ago, I used to get a fair amount of stays of arbitration. When I say fair amount, if I had 7 or 8 in my life, that would be a lot in the public sector. And recently, I've certainly made up for it recently, because the stays I've gone for recently, you can't win one. And it's gotten to a point where, and I consider this to be one of the biggest concerns right now, employers are forced to arbitrate for things that they never agreed to. So I'll give you the best example. It's an active case in Watertown where they do have a clause that says there'll be 15 men, they say men, not being sexist, men on duty during each shift. And we abolished captains there. That's not what I was hired there to do. I was hired there to look at the clause, but they decided they would take the first step of abolishing captains, and $500,000 worth of litigation later. Those cases are still not over, but we went for stay because there's not one clause in the contract that has anything to do with captains. I told you the clause that's in there, and the clause saying men, and men has a reasonable relationship to their claim that you have to have a captain on every piece of apparatus. Now, you don't have to be a lawyer to understand the logic or lack thereof in that statement. That's the law. And I've been back to those judges in the 4th Department. They say, weren't you just here a couple of months ago? I said, yes, Your Honor, I'm hoping to get you this time. I got one more in front of me, the one I was hired to do, and I hope we can prevail on that. But it's dangerous because, in case you hadn't noticed, I didn't notice an arbitrator's name on the list, but at times they do dispense their own brand of industrial justice. They have their own prejudices, just like everybody else, for better or worse. I've done pretty well in my life in arbitrations, but they scare the hell out of me because once you get them, it's very, very difficult to have them vacated. So right now, to me, one of the biggest problems is I find employers throwing in the towel, and I don't blame them now. I'm throwing in the towel in Watertown. We're not going to get a stay in the 4th Department. Because if men could be construed to mean captain on every piece of apparatus, and they say it's reasonably related, that's the standard they use, it's really frightening. Many of these issues are in tailor-made, so I finally did whittle it down to what I considered the most important ones. And the first was the one I just talked about, and that is the issue of the stays. It's a judicial remedy. I don't know, how we're going to do that and get it resolved, but we're working on it. The second is PERB. The Public Employment Relations Board right now has a chair, John Woronius, someone who worked with him, who I'm pretty close with in John's prior life, said, and he's a very, very bright guy, very smart guy. I know him, I won't say relatively well, but I do know him well. And he's very smart. And my friend who worked with him said, as smart as he is, he's more liberal than he is smart. which if you're a management lawyer, is a little scary. And I'll give you just one example of a recent case. Those of you who are familiar with Section 71 or 73 of the Civil Service Law, it's called a no-fault way to remove people, because in the old days, if you had someone who was legitimately sick, out for a long time, you had to hold the position open. To get rid of them, you had to bring them up on charges, and there was some stigma attached to that. They were disciplined, you say you were unfit, you would remove the person, and the state said, yeah, that's not really fair. This guy's really not unfit, he didn't do anything wrong. So they put in these two statutes to remove someone who's injured on the job or off the job. If it's on the job, you get a year out cumulatively. So 6 months here, 3 months later, you get to a year, you can remove the person. If the person is hurt off the job, it has to be a year consecutively. So now PERB has decided, it was an ALJ decision, went up to PERB, we're now in the courts with it. They say you have to negotiate the procedures to remove these people. The procedures, in my view, have always been, you have to give someone notice and an opportunity to be heard. It's called due process. So we say, we have evidence you've been out for a year. It's based on this injury. We have, if it's a job related, we have workers' comp claims. Let us know if you want to contest it. That was the end of it. Now we have to negotiate a procedure with the union on how to do that. And if you have police or fire, that will go to interest arbitration and cause delays. So what used to be a year could now be 2 years. PERB I've talked about already. The interest arbitration, I will just tell you this briefly. I'm a little bit over my time, but I'll take a couple of minutes because I'm very senior. And I can blame it on a senior moment. In any event, the interest arbitration, there was a study done in the early 70s of interest arbitration, what impact it had by a guy from Massachusetts. It was just like Taylor. Taylor never came to New York. He was from Pennsylvania, a brilliant guy. In fact, the reason it's called the Taylor Law, I'm told, is that no legislature would attach their name to it because it was very unpopular with the unions at the time because it prevented strikes and there was no interest arbitration. So in any event, he did a study and said there's no difference between interest arbitration and not having interest arbitration. Now I lived through that in the early 70s and mid 70s, and I said, that's not a reality. We've represented, I wouldn't say hundreds, but probably close to 100, done maybe in my life 100 interest arbitrations. And believe me, there's a difference with interest arbitration. It has a tremendous impact, not just on that employer, but everybody else. Everybody else says, well, why go to interest arbitration? Arbitration is just going to add up everybody else and give them what everybody else is getting. Well, if you were able to give what everybody else was giving, you wouldn't be in interest arbitration. So it's usually the poorer communities to go in there. So when the guy does averages, you're averaging in the lowest paid, the highest tax with the wealthiest. It just doesn't make any sense. And I don't see it going away. And frankly, they updated that version at the last 50th. They did it the 40th anniversary when I was on a panel. I was in a large room. There must have been 400 people in there. And I said, how many employer reps in here? Put your hands up who are in municipalities subject to interest arbitration. And there are not as many union, there are about 100, 300 union people there. They get union leave to go to the conferences. But those guys, they raise their hands, and I said, okay, keep them up. How many of you believe what this guy just said, that the world isn't different in police and fire by interest arbitration? Leave your hand up. There were about 8 out of the 100 that had their hands up. So it truly has had a dramatic impact. You can't get rid of it now, because quite honestly, I deal with police unions who never negotiated without interest arbitration. I don't know that they would have to handle it. The improvement is Long Beach is fiscally distressed. I just started this interest arbitration. I'm going to find out what that 70% means, because I don't have a clue what it means. I haven't seen any analysis of it. Someone from Jamestown is going to give you a little bit, the mayor is going to give you a little bit more of an interest on that. And I think they have to have a little bit more of a impact of the 2%, the tax cap everyone's suffering under, because I lived through the wage and price controls in the early 70s. It was 5.5% back then. Everyone settled for 5.5%. Here, not everyone settles for 2%. And when 2% isn't always the tax cap, it can be lower, it can be higher. So I think they need that criteria there. And the last thing that I'll talk about is the minimum manning. I'm pretty close to the time you gave me. And the one thing you have to understand, a minimum manning provision is a no layoff clause. And let me tell you, to get my chief of the fire department to say that, he doesn't talk to me very often, but to get him to say that, he finally said to get to the 15-man minimum, I'm not exaggerating, he said he needs 61.2 men. I don't even know what he was talking about, because you have 15 in a group and you have 4 groups at 15. 15, they have to get off, they get 1550, that's 60. If you ever look at the amount of time they get off, it's unbelievable, so you have to fill those in. So you don't have to fight that it's a no layoff clause, because, as I said, the cases back in the 70s, the Bowen case from Long Beach, it doesn't say that they understand that minimum is a no layoff provision, but they say it is a different kind of clause, but you use the same criteria to decide whether the clause is enforceable. And I'm going to close with what they say it must be and why. The Court of Appeals did a case called Johnson City. It was a no layoff clause. Well, it helps me tremendously in my minimum manning clause because they're treated the same. But they said, if you want a minimum manning clause to be enforceable, it has to be explicit. So you better say in there, you can't lay off, you can't abolish positions, because those were the two issues in Johnson City. They had a no layoff clause, they abolished the positions clause. Said, too bad, you didn't put abolish the positions in there, they can abolish the positions. You better put, we've considered all the economic consequences of this. That means we can't do other things, we have to keep these people employed no matter what happens. So it has to be explicit. It has to be of a limited duration. What that means, we don't know. I believe every police and fire contract now is an unlimited duration because they have the tribal law that keeps it going on. If they have a good minimum, City of Yonkers, I used to represent them. In fact, I invented when I brought it to Watertown for Yonkers, and then the administration changed, and then they brought in other lawyers. But Yonkers is probably the most strangling fire contract in the state, and they just did negotiate from 2008 until about 2015. They said, we got a minimum manning, we got our side jobs, we got our health insurance, we have everything we need, and they held out, and they kept their minimum manning clause. And that's the problem with the Triborough Amendment giving an unlimited duration. And then the last thing, and then I'm done, which is not too bad, I don't think, well, maybe I can't find the clock. The last thing was that it can't be negotiated in a time of fiscal stress, because they understand that you're going to do stupid things during that time. You're going to give up long-range goals to get short-range things, and you shouldn't do that. And the last quote from the Court of Appeals is, this is to save the public from basically the people, elected officials who give the store away, and, quote, the whim of arbitrators. So, thank you very much.
All right, Secretary. If our audio team, I'm going to do a laudable. If are these mics on the tables going to be live? Because it saves some time. We might have the next speaker speak from their chairs. But anybody on the audio team, that could be good? Yes? Thumbs up? Cool. So I'm Dave Lombardo. I'm with the Times Union. I will be serving as a moderator / shepherding things along for the last few minutes of the forum here. And we're going to hear from 3 panelists and then take a few questions after that. So hold everything till at the end and we'll call on you. First, we're going to hear from Elayne Gold, who has nearly 3 decades of experience with collective bargaining and is the founding partner of her own firm. Then we're also going to hear from Jay Worona, General Counsel for the State School Board Association, which has 750 school districts dealing with at least that many labor contracts. Then our final panelist is going to be the Jamestown Mayor, Sam Teresi. And Sam is living this on a daily basis. He has to budget and negotiate with public sector unions under the Taylor Law. And we're going to stick to about 5 minutes per speaker, and we'll move this thing right along. So Elayne, you're up first.
Is it on?
Yes, you can say yours.
I'm not good with microphones.
You're doing excellent.
3 decades. You shouldn't.
Yeah. She was a child.
I said I was 5, and the mayor said maybe I was 6, so I'll go for 6. Like Terry, the bulk of my practice is in public sector labor relations, management side negotiations. I'm not quite as cynical as Terry about labor relations, but I enjoy it clearly as much as he does. If you haven't read the report, I think everyone has a copy of it. I read it. Now, I've been doing this, as we heard, for 3 decades almost. It's a really important must-read, I've got to say. If you're getting into public sector labor relations, and even if you're a practitioner, even if you've been doing it for 3 decades, I got to tell you, read some stuff in there and you learn things that you didn't realize before. Terry made a point about past practice. Right, we sit down and we bargain. So that's what I do both basically for a living, I bargain. You sit down and bargain, at the end of the day, you're going to do ratification. Union's going to ratify, management's going to ratify. I probably never once in those 3 decades gave a second of thought to that. A past practice is something that's not ratified by the parties. It just happens, it's open, it's unequivocal, everyone expects it as if it's in the collective bargaining agreement. Sometimes when you say a past practice, you look through the contract to see if it's really in there, and it's not. I never gave that a thought. So for me, I'm thinking that every person that we hire in our office is going to read a copy of this report. If not for the substance of it as a whole, certainly for the historical perspective of what it means and how it was developed, I think it gives you really good insight as to where we came from and where we are today. To me, the tailor law itself serves as our rule book, whether we're bargaining or whether we're doing any type of labor management or grievances, it's all found right there in the tailor law. The bigger issue for me in my practice is my clients appreciate that it is the tailor law, but they really want to know what is the practical implication of those laws. What is the practical implication and impact of PERB's decisions? And I agree with what Terry has said. I think PERB has gone a little far afield. I think that what troubles me many times is they're not looking at the practical impact of their determinations on the parties. It's great to read the statute and be a strict constructionist, that means letter of the law. You read it just the way it's written on the piece of paper, but that's not reality. If it's not going to be a living and breathing kind of statute that moves with the times and changes the way the parties need it to, that seems to be doing a disservice to the public. The fact that PERB almost never considers economics as an issue or as a defense or as an explanation in any type of proceeding is mind-boggling to me. I think looking at those realities really makes a big difference. We live in an economic world. Yes, if we go to interest arbitration, that's swell. You could talk about economics, but sometimes when you're at PERB and you're doing a case, whether it's on past practice or unit work or subcontracting, I'm not sure if I believe that subcontracting should be totally thrown out of the box, but there's got to be some give and take and some understanding from PERB on a balancing test. If you're not going to look at economics as part of the balance or consideration when you're doing that balancing test, something's missing in the picture. I think it's important to educate everybody that's at the bargaining table about what they need to do and what they need to see. We started doing in our bargaining because economics are a big issue clearly for all of us. We have to tell folks and understand, even from our own perspective, I'm not sure my own client understands, that it's more than salary. It's more than just the base wage that makes up what an employee gets, what's the cost. You have to look at health insurance, you have to look at the pension, because municipalities pay money into the pension system. You have to look at all the other benefits. All of that is the whole package and the cost, the true cost of an employee. Days off can turn into money if you backfill a position. Whether it's police or fire or DPW or nurses or clerical staff, it's going to have a similar type of impact. To me, the best part of the tail law is the impasse procedure. Since I'm a negotiator, at the end of the day, I think all aspects of bargaining, from the first moment you're in that bargaining room and exchanging your proposals, even to the final time that let's use police and fire, that an executive session renders an award, you still have the opportunity to bargain your own contract before somebody imposes it on you. And even if you're doing fact-finding, until the legislature is in position, the parties still have the absolute right to negotiate their contract and make a deal. Terry and I are on a statewide board, the Public Employer Labor Relations Board, and we always talk about how upstate and downstate sometimes are a little different. You could hear from my accent that I'm born and bred in Brooklyn, but I've lived up here for those 3 decades that I've been doing labor relations. And I find it, bless you, we generally have a good rapport with your adversary here. I always say that my adversaries are adversaries with a small a, because you build a relationship, and the building of that relationship makes a difference on whether or not you could ultimately reach a contract. Our arbitrators trying to be creative, despite the report seems to indicate that the folks who wrote it didn't think so. I find that every now and then you find an interest arbitration or even through fact-finding that folks are trying to be creative in coming out with decisions and considering the ability to pay. The city of Albany just went through an interest arbitration with its police rank and file unit, 270 or so men and women, ranks of patrol, and detectives and assignments, so rank of patrol. The term of the award was 14 and 15, 2014 and 15. They got 2 zeros. 2014 0, 2015 0, sorry, 2015 1% effective the last day of the award. So in essentially 2 zeros. That wasn't doing comparables of other jurisdictions. It looked in the city of Albany at its 11 bargaining units and the history of what other units got over the time period. And it looked at the 70%. I always said to myself, 70%, what did we do before that? Did we look at 5%, 2%, 1% of the ability to pay? So I'm not sure how 70% is some magic number, but the arbitration panel gave due consideration to what the ability of the city was to pay. And that really goes to the proof that you put in. What kind of proof did we show? And the city there was able to substantiate its lack of ability to pay. And the 1% was just to give some money towards the union, but and yes, it had a retroactive effect because the contract went back to 2014 and 15. So so we had to pay retroactive monies for 16, 17, and part of 18. But in essence, that was 2 zeros like every other unit received in the city, including the firefighters.
Thanks, Elayne. Next we'll hear from Jay.
David, I'll keep you on schedule here. So one of the things I would recommend in your reading of this report is to do it the way I did. I read it on a plane last night at 30,000 feet. It's a great opportunity because you're just in your seat and you're required to read. There's nothing else to do. But sincerely, what I found very interesting about this report is the history portion. And I commend EJ and Terry for a really great report because whether one is on management side or on the labor side, what I think is the most interesting thing about the first section of this paper, which is on the history of the Taylor Law, is that what is considered, I think, primarily by the union right now to be sacrosanct, those benefits that are contained in the Taylor Law, were not necessarily present when the law was enacted in 1967. In fact, those many of the benefits have been enhanced by legislative enactments since the time that the law was put into place. And so I think the point is that if the law was enacted to cure the labor unrest that we were seeing during the Condon-Wadlin Act and even prior to that, we could see that the Taylor Law effectuated that purpose even prior to all of the enhancements that were put into the law. My other observation, I guess, is that I think what's frustrating for school boards is not that anyone ever wants to engage in union animus. I think that would place us in a position to really decide to hate each other a lot more than we love the children of the state of New York that we're supposed to serve, right? And that doesn't really make any purpose here. That wouldn't serve any purpose. But I think that one of the things that school boards are empowered to do is to serve as fiscal stewards for their communities. And what's particularly frustrating, I think, is that school boards might actually evidence a very strong position to ensure that their taxpayers are taxed in a manner that they're able to absorb those tax increases. And sadly, they will inherit collective bargaining agreements that were negotiated either when times were better or by individuals who didn't share the same perspective that a school board might share at this point in time. But in the minds of their community, they are powerless, useless individuals who have not effectuated any change. And that's very frustrating for people who are very altruistic to try to serve as volunteers to serve the interests of their community. So I think there really needs to be a balance between being able to represent your community, represent the children who you are entrusted to provide an appropriate education, and to place ourselves in a position to not just look at the challenges that we are presently facing. This paper makes a really great point about the fiscal strain that we are all under here in New York State. Again, whether you're labor or management, no one wants to be overtaxed. And in many communities, people simply don't have the resources to be overtaxed. The concern and the issue really is not to recognize what our problem is, but what the fix is, right? Because if we were to just say, let's reverse, I think that will be seen by labor as, again, union animus, which really doesn't accomplish anything. So I think what we need to figure out somehow, because that's the challenging part that begins after this paper is absorbed, is how do we get to a place that doesn't return us back to the days when unions didn't have any authority whatsoever, and labor perhaps were placed in the same position in not the best position. In fact, I just a story to explain, even though I have for 34 years represented management, I understand the need for unions. I wouldn't be at this table and on this earth but for the fact that my paternal grandmother was sick the day of the Triangle Shirt Factory fire because she worked there and was not able to be there. So I clearly understand the need for organized labor. And again, I think the challenge that we are all facing is how to get to that place where there's fairness on both sides.
Thanks, Jay. And with 30 seconds to spare. Good job. Mayor, you're up next.
Well, Mayor can't say hello in 5 minutes, so I'll take that extra 30 seconds. I've read the report as well. It's outstanding. We'll make it unanimous up here on the panel. My only qualm is that it didn't come out earlier, because when I was first elected in 1999, that would have been one hell of a resource document and teaching tool for yours truly that has had to develop his understanding about labor relations as well as the legislation, the world of binding arbitration through the School of Hard Knocks. Something like that when I was coming into office would have been absolutely fantastic. By way of introduction and full disclosure, I want to share a few things to you about myself. I come from the city of Jamestown. For those of you that live east of Interstate 81, we are the furthest western point in New York State. Yes, there is a city in upstate New York west of Buffalo, and we are it. We are actually closer to 3 state capitals, Ohio, Pennsylvania, and West Virginia, than we are to our own state capital, and we're one of the few places in the United States outside of Northern Virginia and Maryland that can lay claim to the fact that we're closer to our nation's capital than we are our own state capital. So we are quite remote. We may not be on the edge of the universe, but you can certainly see it from there. A small city of about 35,000, about 70,000 in the region. Industrial power during its heyday, changing economy, becoming more diversified, manufacturing still a big part of the base, heavily unionized manufacturing still part of the base, but diversifying more, hopefully in the eds, the meds, the finance field, arts and tourism, and we're starting to see strides in all those areas and a bit of a nice economic bounce. We hope to keep it going. I was born into, raised in a union family, a union member myself, a lifelong Democrat, union member myself, retired from the United Food and Commercial Workers Union, still carry my withdrawal card with me, and believe that there needs to be balance in the overall scheme of things in all walks of life, including labor management relations. It cannot go too far to one side or the other. You lose the balance, you lose respect, you lose good policy, you lose good decisions, and you lose effectiveness in the process. Also, out of disclosure, my wife is a retiring teacher this year with 34 years in the state pension system. I tried to get her to stay on to get to the full 70% retirement benefit, but she was losing her mental health in the process. It's tough being a teacher today. It's difficult and different being a teacher today. And I've also learned over the years and subscribed to the notion, happy wife, happy life. I want to keep it that way for the rest of my duration on this planet. Also, out of full disclosure, I believe that the original version of the Taylor Law 50 years ago was both a good thing and an essential thing, although the study, the report makes it clear that the ability to strike was not there in New York State. A lot of the protections granted in the Taylor Law and the definition was already there through previous legislation and case law, but I think it was a good thing to codify it and make sure that it was clear to everybody and that limitations were set and that there were also consequences and penalties if you violated the new Taylor Law. But as with a lot of things in life, it's the second, third generation, if you will, the second and third bites at the apple, the appendages that keep getting attached to things that I think sometimes throws things out of whack, and I believe that that's the case with the Taylor Law as well. Specifically with the 1974 appendage of compulsory binding interest arbitration, We've been living with the experience of that. We are now going for the 5th and 6th time in my 19 years as mayor to binding arbitration with our police and fire departments. We are in number 5 with the police department right now. The fire department is waiting to see the outcome of the police arbitration, and will likely live in an impasse with them for a year or so. We'll file for arbitration thereafter. We have an interesting case right now. We're not quite sure how and why we are at compulsory interest arbitration, because we are at 100% of our constitutional tax limit. We have 79% of our workforce currently under Triborough protected minimum staffing agreements, including police and fire. We have eliminated all funding to our senior citizen center, to our library. During my tenure as mayor, we have cut back in every aspect of the city budget, both by layoff as well as through retirement, attrition. 21% of our workforce, most of that done within the first 5 years as mayor. We have offloaded municipal services to the county. We are sharing services with our neighbors. We provide all the utility services for the immediate greater Jamestown area, providing service to another 35,000 residents outside the city. We've cut, we've restructured, we've shared, we've offloaded everything that we possibly can at this point in time, and barely with our nose above the water line. Cut funding the library and every other discretionary area of spending. We're not quite sure why and how we're at interest arbitration, but we are putting to test right now what 70% rating means and the ability to pay means. We've seen with interest arbitration. I have a chart that I put together here. I'll put online probably later today if you want to go to the city's website and check it out. It's jamestowny.net. Some handout materials. I left them in my office. I was going to bring enough to hand out to everybody here. But go to our website tomorrow and it'll be online for you to check out this materials. I have 9 bargaining units for a workforce of 450 people. Including 5 enterprise fund utility operations that are operated on a regional basis. A total municipal budget of $95 million, $35 million of which is in the general fund budget. 6 out of those 9 collective bargaining units are attached to the general fund. The other 3 are attached to our enterprise fund utility operations. If you want me to rattle them off, I will. Police.
We gotta wrap it up.
Okay.
We'll trust you.
Something needs to be done. Our position is that the interest arbitration needs to be abolished or at least significantly reformed to allow sunshine in the process, which we are doing in Jamestown right now. We're the first that we know of to actually have media and the public in the room watching the sausage being made through the testimony. There also needs to be the financial restructuring board alternative of having the financial restructuring board for communities that are in that program serve as the arbitration panel. That is an option right now. Our feeling is that needs to be across the board and get rid of the 3-member panel process, which is highly stacked against the taxpayers' interest in our minds. And Triborough is filled with dozens of unintended consequences, including institutionalizing bad decisions that were made at negotiating tables in long gone eras, and saddling those decisions on both sides of the aisle, union as well as management. That's my story. I'm sticking with it. I'd be happy to elaborate on anything that you may would like to delve further into.
Thank you. Appreciate that. Here for the panel. So we're going to do some questions, just a few, but if anybody has a question, raise your hand. We'll try to call on you, but moderator's prerogative first. I heard a couple people mention PERB affecting the implementation of the Taylor Law. The governor gets to appoint members. Anybody think that PERB might be different or better if members came from someone besides the governor? Elayne, you want to take that?
To me, the people who should be on heard either as the ALJ, certainly as the ALJs, because they're the first line of defense, if you will, and the folks who are on the board itself, if they were practitioners, that wouldn't hurt. I think the board tries to do that. When you get to the board, there's a 3-board panel, there's the chair, and I believe there's 2 other folks that might be done by party. I'm not sure if it's done by Republican, Democrat or not, because I don't know. But to me, if folks were practitioners, they'd have a lot more handle, a better handle on what we do for them.
DJ, did you want to, you stepped up to the mic there, I couldn't tell if you were ready.
No.
No, you're good, okay. Mayor, you're dealing with public sector unions on a regular basis. Is there any, carrot that you think you could bring to the public sector unions to make them make concessions on the Taylor law?
Well, our approach is we try to deal with respect across the table. We have an understanding that they have a job to do, we respect that. They're representing their universe, their workforce, their constituency. We ask the same in return. And I think that while we haven't agreed on everything, in more cases than not, we've settled most of our disputes at the table. Arbitration, unfortunately, is a tool that's available only to police and fire in New York State, and I guess that's my first question, is why is it limited if it's such an effective tool at maintaining labor peace and maintaining public safety services limited to police and fire? I see a couple of legislators in the audience here.
Don't give anybody ideas.
The point is, if it's such an effective tool, why has it been limited to only police and fire? Obviously, you had to draw the line someplace. Every member of my workforce is in public safety. And to create a dual system of haves and have-nots is wrong. And you can't have a system of only haves with taxpayers paying out the door all the time. We try to make sure that our feelings are known from a policy level, but also an educational level with educating members of the public as well as our workforce, that ultimately the rubber band breaks if you keep pulling it too far.
Do you have a question? Can you identify yourself?
Sure. My name's Anthony Powell.
Anthony, we got a mic coming to you.
Thank you. My name's Anthony Powell. Part of my question, in Suffolk County, on Long Island, there's a significant amount of conversation about pay to play and limiting campaign contributions on behalf of subcontractors that do business with that municipality. But rarely do I hear a lot of conversations about campaign contributions from public sector unions, understanding that a lot of change that would ultimately be implemented is being done by the legislative body or the chief elected officer of that municipality. How do you begin to have conversation or implement changes when there are campaign contributions going to those elected officials from the public sector unions?
As the only elected politician, I went to the dark side of public service in 1999. Before that, I was on the career side, planning and development director for my city. But I believe campaign finance reform is absolutely essential. There's way too much money in the process. Unfortunately, I, as an elected official, I'm a full-time mayor. This is my job. It's not something I do on the side and maintain a couple of other careers. I have to raise money. But I have also, to paraphrase Lyndon Johnson, I shall not seek nor shall I accept endorsements and campaign contributions from public sector employee unions that I have to negotiate across the table from. I was proud in my last election to have endorsements from 37 private sector unions as well as the AFL-CIO chapter in Chautauqua County. But I think that there is a conflict of interest there to accept campaign contributions. I know a lot of my colleagues out there do, and a lot of my colleagues don't. And I think that there needs to be, as part of campaign finance reform, and I would highly recommend it, looking at restrictions as to where you can and can't accept contributions from. Namely, if you're dealing with people and you're supposed to be representing the public, you shouldn't be taking campaign contributions from the very unions that you're negotiating with and having to deal with disciplinary matters, oversight disciplinary matters. So yes, I'm a strong supporter of campaign finance reform and putting limitations. I know that some of my friends out in the audience are going to consider that I'm trying to put limitations on the First Amendment. Well, I'm not sure of any of the amendments in the Constitution that do not have limitations on them, including the First Amendment. This would simply be another one.
Since from Long Island, could I just add a little bit to that? It's an incredibly political situation on Long Island. The unions have undue influence. There's a reason the police are the highest paid in the country, in Nassau County. They've been very active politically over the years. And I think the only way you do change that is if you bar the contributions from the unions to the elected officials. It's, well, people running for office, it's, I guess it's part of democracy, but it's really a slanted view of it. You know, just recently we had the town of Hempstead, the largest town, I think, in the country. Their incumbent lost. It doesn't matter what party he was, but he lost the election. And think about it, he spent $1 million on his election. He was defeated by a candidate who spent $73,000 on her election. They were so fed up with a lot of the government there. On his way out the door, literally, during his lame duck, he made a deal with the union. No layoffs for like 6 years, and gave increases to tons of people. And they were all his people. They were the people who were there when he was there. It's illegal, supposedly. It's being challenged right now. But I've seen it done before. That's something, in fact, I think in our first report, we have made recommendations that if you're a lame duck, that should be the end of your tail-law responsibilities. From November to December, the amount of harm you can cause, long range, is unbelievable.
Senator Savino, do you want to make a rebuttal?
With all due respect, if the unions, the public sector unions decided not to do direct contributions to elected officials, they could do it today and still have the same influence. They could just establish independent expenditures and spend money unlimited on campaigns to promote the candidacy of individuals without directly coordinating with them. So they could have the same influence. I think it's cynical to say that they shouldn't be able to contribute directly to candidates. I think it's cynical to assume that they're buying elected officials. I don't really think that's the campaign, and that's how we achieve the kind of campaign finance reform that I think that young man was talking about. Unions have the right to participate in the public square. They have the right to exhibit their First Amendment rights the way everyone else does. I mean, the Supreme Court has already ruled on this. This is speech. Money is speech, and unions have the right to do that the same way everyone else does. So I think that the question you were asking is a little bit different than the answer that you got. And again, I will say this. You're not going to quiet the union's ability to influence public policy. They'll just do it in a different way.
Thank you.
Can I close with one other question, because it's actually an important issue to be clarified?
It's your panel, so I'll allow
Well, I
it.
just want to, actually, several people, including me in passing, mentioned an issue I think it's important to understand, which is eye-opening. The phrase past practices. Would somebody care to explain, to give examples, because explain, a past practice is something that PERB effectively has ruled, and that is being litigated around the edges, is some right or privilege an employee has that was never actually granted formally through a contract. Basically, somebody agreed to do it. But could some people in the panel give examples of that? Because it's actually important for those in the audience who are not familiar with it to understand what a past practice is and where we are in that situation.
The best example I can think off the top of my head is people are providing cars in their jobs, take-home cars. Never agreed to with the union, never signed off on by the legislative body, never agreed to by the chief executive officer. I've had mayors come in who inherited this and say, why are there 40 cars going home every night? I don't need that. But if they're in unions, they take it away from the non-union people, but the people who are in unions, PERB will say it's a practice that's been in existence long enough for them to expect that it's going to continue, regardless of who agreed to it. So that to me is a very expensive one, and one that most people can understand.
It could be something even more simple than that, right? It could be something that says people use their sick time for family members. Maybe the collective bargaining agreement defines sick time and says it's for your own personal sick leave. But over the years, the department head in a particular department allows folks to use the sick leave for their kids, for doctor visits. If it's done unequivocally and open and people expect that it really is in the contract, it becomes a past practice, even though never agreed to or explicitly in the contract.
I actually have an example, EJ. So, and occasionally you lose on this one. So, many years ago, under the Social Service Employees Contract, there was an out-of-title clause that said that if you were assigned to perform out-of-title work, that you could be compensated for the higher salary pursuant to filing an out-of-title grievance within 30 days of the assignment of the out-of-title work. However, no one ever enforced the 30-day filing of the out-of-title grievance. And so ours was a union that represented the entry-level title and the supervisory title, which was rare. So you had caseworkers, supervisors, supervisor levels 2 and 3. So it was routine for the city to assign people to do out-of-title work. And what would happen is people would wait, and they would file their out-of-title grievance a year later to kind of like build up money. And the union would pursue the grievance, and the city would settle it, and you get this big retroactive pay. This went on for years. And the Office of Labor Relations would always approve them, even though the contract said you had 30 days to do it. Well, after about 20 years of this being common past practice, the Giuliani administration took a look at the contract and said, your contract says you have to file within 30 days. So, at the first case that was filed, they said, yes, you're doing out-of-title work, yes, you're entitled to be compensated, however, you're only getting 30 days, even though you've been doing it for a year, because your contract says. We went all the way to appellate arbitration, and we lost the case, because even though we had years of past practice, the contract said you had 30 days to do it. So, it's a perfect example.
That's not really a past practice case. That's called,
That's how it was.
they reverted to their rights under the contract. It's called reversion. If you have a clause that says exactly what you said, it doesn't matter whether you did it wrong for 20 years. The employer is always entitled, either side is entitled to go back to the language in the contract. Past practice that we're talking about only apply to things that are not covered by the contract.
So, third row, the gentleman, the young gentleman, yes, you, sir. Just make sure you identify yourself.
Yes, my name is Pete Mineaux. I'm currently the chairman of the New York State Public Employee Conference, comprised of 81 unions in New York City and New York State. Let me state for the record, on behalf of my organization, we view the tribal amendment as leveling the playing field. As to the question about having to deal with what happened before us, well, guess what? Union presidents have to accept the provisions made before them. Management has to accept the provisions made before them. You have the right to negotiate and change them. But really, we have to deal with what we have. And the tribal amendment does protect the union, because I would venture to say that in all the years that I negotiated my contract, I would start to negotiate my contract 6 months before it ended. It was the mayor or the governor or the county legislators that would make the contract go past its expiration and then complain about the retroactivity. Well, if they would sit down with the unions and negotiate prior to the contract, wouldn't have that problem. You need to state that for the record.
Oh, well, okay, but we'd like to do questions from the panel from now on, and you guys can share experiences afterwards. We'll be all.
Well, they can answer that if they like to.
That wasn't a question.
Okay.
Young whippersnapper in the back. And this is the plan.
Ken Gerard, I'm an analyst at the Empire Center. A question for our panelists. With the Supreme Court potentially ending agency fees, how do you see that affecting labor relations in New York in the years ahead?
Jay, you want to take that one?
So, I think that the way things have worked, prior to what most people are predicting the Janus case is all about, is that I think and I know the unions are very concerned and nervous about this decision. I've been on a number of panels nationally talking about this, and what I find interesting, and I don't say this cynically, I just find it interesting that unions will say that they are fearful about this, and what's disconcerting is that if individuals really truly believed in their unions, right? I mean, then there wouldn't be any fear. Then they're just going to join. I mean, maybe it's a greater pain in the neck in terms of getting the union's dues. But if there is a perception that the union has great value, then nothing really would change. I think what's the big change agent is not the Supreme Court. In the Supreme Court, if they issue the decision that is predicted, to me, I think the big change agent is millennials. And I don't say that in a pejorative way because I own 3 millennials. And I've been in my job for 34 years. That was considered the thing to do. You got a job, and if your employer loved you, you'd stay forever. What millennials do now is, and my kids are great examples of this, they're doing spectacularly well out in California. But they've had a number of jobs since the time that they started, and that is a badge of honor. In fact, if you stay in a job, it's considered to be not such a badge of honor. So what's my point is your subtext. The point is that if you don't really have a desire to stay in a job for a very long time, there might be a perception that the entity, AKA the union, that would protect you will not be as necessary. And therefore, if you have a choice as to whether you're going to fund it and pay for it, you might choose not to. And I think that is going to be a significant challenge for unions, and I think the big challenge in the way that's going to be realized is, many people in management believe that unions eat their young, meaning that, of course, what you do is you really strive to make your employees that have been in the workforce for a lot longer happier. And I think at this point, unions will have to readjust that mentality and think about how we can attract those young people immediately so that they can see the value. I think that will be a game changer for unions.
So you mentioned millennials, and as one in that class, I think about the alternatives that are available to me, and I have to say that the public sector unions make a very attractive, compelling case for somewhere I'd like to work. So is the Taylor Law necessary then to attract people like me? If it wasn't for the Times Union, maybe I would have gone back and exerted what little capacity I have somewhere else. But for more qualified people, is the Taylor Law necessary to attract a good workforce?
Well, I don't think it hurts, certainly. But my point, though, is that, if you even look at retirement benefits, I mean, the retirement benefits that young people now coming into the state system achieve is a heck of a lot less lucrative than the retirement benefits that people would get years ago, right? And so I think that, yes, the Taylor Law does provide a great advantage for individuals, but all of that is presuming that they're going to stay in the workforce.
Sam, do you want to weigh in? Who's fake towards the mic?
I don't have a crystal ball on Janus, and the only thing I can predict is in today's day and age, the only predictable thing is unpredictability now in Washington and on the Supreme Court. I don't have a clue as to what long-range implication that's going to have for us on the ground. As I said before, I think the Taylor Law provides a set of playing rules, stability. I think that that's important in my experience without trying to recruit a young and mobile workforce. And I know that this isn't necessarily the topic of today, but another thing that would be beneficial to us with a very strong, and I'm much appreciative for it, terrific public employees retirement system that we have. That has become a point of attraction, but I think having a component of a defined contribution plan as an alternative, as an option, would also go a long ways to attracting millennials who may not be looking to sign up for a 35-year career in government.
Mike Fitzpatrick, 8th District, Suffolk County. Diane's already snickered. My buddies from the Suffolk PBA here as well, but before, Diane was absolutely right. I agree with her how the money will find another way into the system, and I felt the full brunt of that about 3 cycles ago with my friends from the PBA, because I put in a bill to put a 2% cap on binding arbitration and a couple of other provisions. They asked me to pull it. I respectfully said no. We had a conversation, and I still won with 65% of the vote, but I frankly enjoyed that campaign because I went out to the different venues and had a conversation with my constituents about, and I'm not anti-union, although they may perceive me to be, but Mayor, you brought up the concept of balance. And I believe that the way you get around this, or we get through this, the issue of compensation for elected officials, I think, is a problem. Because when elected officials get a defined benefit pension system, pension plan, what does the system reward? Longevity. So now I'm incentivized to stay here as long as possible. So, and how do I do that? Well, when they come knocking on my door and, well, we want this, we want that, I'm all for collective bargaining. The problem is, in my opinion, the unions don't want to use it. They'd rather use the legislative process to get benefit enhancements and pension sweeteners rather than put something on the table and negotiate for it.
Try to end this with a question.
So, well, the question is, the idea of a defined contribution, getting elected officials out of the defined benefit system, I think is critical. We should cap it and close it. I just like your thoughts, because right now, elected officials' interests are aligned with the unions, not with the constituents they have a fiduciary responsibility to. And I think the defined contribution, capping it and transitioning every one of us from governor to town council, I think would address that.
I don't think that we're ever going to get rid of the defined benefits plan. It's there, it's constitutionally protected. Politically, it's not going to change. My point is having an option available for those, particularly those that are in more professional type of careers in government service, may not be looking to make a lifetime career out of it. Longevity isn't their reward. Experience is. And then moving on to maybe more lucrative type of practices, I think that a defined contribution plan, a well-structured one, that's more along the lines of what happens with university professions in New York State, offering that as an option, I think would be a great recruiting tool for us at the municipal government level, that we simply do not have the firepower to compete sometimes with the private sector for the best of the best people out there.
And unfortunately, Jay, we're going to have to save your 30 seconds for the next forum. But thank you again to our panelists, and hear for them next time.